Picture this, your product just went viral, sales triple overnight, and then, bam, you get hit with a cease and desist for trademark infringement. Or worse, your AI-generated logo turns out to be similar to someone else's trademark. Welcome to the new IP Wild West. Welcome to Letters of Intent. I am Pankaj Raval, and I'm joined by my co-host Sahil Chowdhury. Sahil, how are you today?
Doing great. And I'm very excited about our topic today.
Yes, Sahil's talking to us from the other side of the world in India with his ear to the ground, listen to what's happening in terms of global trade. And today we've got a very exciting episode. Today we're talking about how AI and e-commerce are rewriting the rules of ownership. We're going to be diving into intellectual property as your biggest asset and also your biggest liability, especially in the world of e-commerce and AI. So if you have an AI business, you have an e-commerce business, if you are involved in those businesses, this is an episode that's for you, and you want to make sure you're paying special attention and reach out to us if you have any questions, because I think we're going to cover a lot of really important stuff that's going on today. The world is moving fast and you got to be in the know, otherwise you're going to be facing serious exposure.
So, Pankaj, you're right. I'm in Mumbai, and today the world has never felt smaller. I mean, between being able to video chat, the world has ChatGPT at their fingertips, e-commerce, your manufacturer, your selling. We are in a very interconnected global world where people are working together, people are designing together, people are creating together, and people are stealing IP from each other too. So I want to give an example here. Your product listing just went viral, sales triple overnight, and then bam, you get a cease and desist for trademark infringement. Or worse, your AI generated logo turns out to be similar to someone else's trademark. Welcome to the new IP Wild West. Pankaj, you have a lot of experience with IP, and it seems like the space is being transformed. So I want to kick off this conversation by asking you, what would you do in a situation like that? How are we supposed to think about the new rules around IP?
Yeah, Sahil, this is a real life example. We're seeing this happen right now. We are getting notices from clients who have been accused of trademark infringement, of copyright infringement, even for one client who was publishing blogs early on when ChatGPT first came out, and they got a cease and desist letter, a kind of a nasty demand letter from a competitor, and the competitor saying, oh, you're essentially stealing our blog content. And while my client created in ChatGPT, interestingly enough, the content that my client was using was somewhat similar to what was being featured on the competitor's website. So it means that ChatGPT probably, used that data for training and then spit out something similar. So it just shows you that you've got to be extremely vigilant today with the content you put out, even if it's done by AI and ChatGPT. People have got to know that it's trained on content that's already out there, and oftentimes it's copyrighted content. Oftentimes this is content from major news sources. They don't always have the access or the rights to this content, as we've discussed in the past. Right now, there's a big lawsuit between New York Times and Anthropic. There's also a lawsuit in the UK going on right now with Stability AI. So this is all working its way through the courts, and there's going to be a lot of discussions about this. I know there was like a $1.5 billion resolution recently with Anthropic. So it was a settlement. Stuff is all coming to a head now, and people are going to recognize that the law generally is slow to catch up, but it will catch up, and people are going to figure out ways to monitor this, to monetize this, and it's a matter of time till you might get a cease and desist unless you're doing the right work ahead of time as far as clearing your copyrights, clearing your trademarks, making sure that no one else has a confusingly similar brand, even if you created something using AI.
So to kind of take a step back, if you are a small business or a large business today, you're dealing with AI art scraping, counterfeit products, software code reuse, other forms of data scraping. You are in a landmine in terms of figuring out what is protected and owned versus what is available for you to use. And there's a very blurry line now between infringement and inspiration.
Yeah,
And
absolutely.
it's not just, big brands anymore. Small businesses are getting caught in the crossfire, and it seems like they're often both the victim and the violator without realizing it.
Absolutely.
Yeah, have you seen that play out for our clients where they're both the victim and the violator?
Yeah, I think it does happen in a lot of different contexts. We've had issues with clients who had patent disputes, and they were a victim in the sense that they bought the IP. They bought the products from a distributor out of China who says, "Oh yeah, this is our booklet of all the different items you can sell. You can put your brand on them and you can sell them." And then they were also the violator when it turns out that, well, actually some of these items were patented by a very large company and they had no idea. The issue is then what do you do, right? Can you go after this company in China? Are they going to indemnify you? Probably not. This is where it gets really complex when you talk about cross-border deals, and people have got to know what are the rights, what are the remedies when dealing with someone cross-border. If you're dealing with someone in the U.S., that's one thing. You have contractual rights. You can enforce those rights in certain states based on your choice of law, but it gets a lot more complex and potentially a lot more expensive now when you're dealing with someone overseas. How do you enforce the law? Where do you enforce the law? What are they going to do? Are they going to pay you? Do they have money to pay you? So these are all things you got to think about when you're entering into deals on cross-border transactions, and why I believe, not to toot our own horn, but why counsel is so important, because you can really be caught with your pants down if you're not careful.
That is so true. As counsel for a number of fashion brands, I found that the supplier agreements were often handshake deals, and we would implement contracts and supplier agreements that would include IP provisions, but most of the time, small to mid-sized businesses are getting involved with a supplier not knowing where the artwork is coming from that is being used as part of the manufacturing, not knowing if there's a license involved when they are using artwork or some kind of design element. And like you're saying, this creates a downstream effect where you could be the victim of someone else's copying or infringement without knowing it. And then now you become the violator and you're passing that downstream. So, what are some tools that our clients could use to try to avoid that? There must be some kind of defensive measures, some kind of preventative measures that a client could use when they're working, let's say, with a manufacturer.
Yeah, it was a great point. It's a great question because you would think in today's age there's going to be more tools to help people kind of clear these things. I know on the trademark side, because we do so much trademark work, there are a lot of like great tools out there that we use that we pay a lot of money for to help clear trademarks, to help look at them, look at the use. Because the thing is, when you're trying to create a brand, you got to look at not just the rights here in the U.S., but really should be looking at who's using this name globally. Because if you're trying to expand into other countries, you may have problems if someone's using that name in China or the UK, because now that could severely restrict, especially if you're e-commerce product, where you could sell it. So of course, it depends on the type of product. If it's a service, it may not matter as much, but things to keep in mind. And then on the copyright front, yeah, you should be clearing copyrights. You should be understanding, okay, if you created it on using AI, you want to make sure you're using an AI service that has rights to it. So for example, Adobe, I believe, Adobe Fireflies, I think it trains its graphic generation on its own content. If you create it in their Adobe, then you would have the license to it. But those are things to keep in mind, because if you're now using ChatGPT, other services out there, other models that maybe train on data it doesn't have license to, it just scrapes. Now you could be running into issues later on if it used and repurposed data or images that didn't have rights to. And copyright, trademark, these are not like, okay, exact match issues. There's not even, there's a myth out there that's saying, oh, if you use less than 70% of an image,
Right.
then you're not violating the copyright. That's not true. Copyright is all seen on a case by case basis, and you have to recognize there's statutory damages involved with copyright law. Where if you're found to be in violation of a copyright, now you could be owing 750 to like 15,000 initially. If it's willful, a whole lot more, up to $150,000. These are significant amounts of money that you could be looking at. You want to think about registration of the copyright, and also you want to think about trademark or patent, but also as the kind of offensive mechanism, but also defensively clearing these things, clearing patents, clearing trademarks, clearing copyrights, and even evaluating your trade secrets too to determine what can be protected, how do you protect it, because the name of the game is IP going forward, and you want to make sure you have a very strong system and process around protecting it and ensuring that you can secure the integrity of that IP.
You brought up something really interesting, which I think we usually treat as boilerplate, which is venue and choice of law.
Yeah.
If you are a business today, and you have IP, that's a very important provision to pay attention to. What do we usually suggest if someone's doing cross-border transaction? Do we usually suggest an international arbitration group? Do we usually suggest that a client go with a certain country in terms of venue? How do you think about venue and choice of law?
Yeah, it's a great question. It's a very kind of complex question and very important though. A lot of people don't think about it. You're right. A lot of people just gloss over it in a contract, but as lawyers, or you and I deal with this daily pretty much. It is a very important question and oftentimes can be subject of a lot of discussion and back and forth because where venue is, where the choice of law could really matter in terms of your rights. So, yes, if it's a truly international transaction, commercial transaction, then you can, and depending on the size of the parties, I think international arbitration is great. There's services, there's courts that you can use for international arbitration. If you're a U.S. company, if you can get the venue and governing law in the U.S., even better. For some clients are going to want it in the U.K. You have to think about travel. What does that look like? You have to hire counsel there now if there's a dispute. Better to have a home court advantage, I think, in almost all situations. But if these are two large companies, then I would say international arbitration is a great option.
Bunkage, I know that we had a client that was selling T-shirts with the names of famous pop stars. And it turns out those names were trademark. And by putting the names on T-shirts, that client was selling counterfeit goods. What level of exposure does someone have who's in a position like that? Why is this that serious?
Yeah, it's a interesting issue because people think, oh, you see people selling T-shirts all the time, outside Staples Center or sorry, Crypto.com Arena and all these other venues. You see it everywhere, and people now are doing it online all the time. But if you don't have the rights to those images, if you don't have the rights to those names, now you could be facing serious liability, and that's actually considered counterfeit. You violated counterfeit laws, and those statutory violations could go up to $2 million if they're willful. It depends on what is actually violated. The reality is that oftentimes when we look at judgments by courts, even if they are pretty egregious, you don't see them to be in the $1 million or maybe in the hundreds of thousands of dollars. It could get up there pretty quickly, especially now when you're looking at attorney's fees that you could be also on the hook for. Could be a lot more than that. If you're selling stuff online and you don't know always the source, or if you know the source, if you made these products and you didn't get clearance for some of the trademarks, and the trademarks could be the pop star names or images, then you could be liable for significant damages. I know this client was almost a 6-figure settlement we had to negotiate, and that was after a long time where initially they asked for damages in the millions. So we were able to negotiate it down significantly, doing our diligence, looking at what other cases these people have filed. We worked hard to figure out what are our angles to get this as low as possible, and eventually we were able to settle on something over a long period of time in terms of payment that was feasible for my client. But he learned a hard and expensive lesson, and we were able to help him out. But these are issues that come up all the time, and if you do get a cease and desist, if you do get a lawsuit, someone files against you for copyright, trademark, we can definitely help you and help try to negotiate a favorable resolution for you, so you're not stuck litigating, or worst case with a massive judgment that you've now got to deal with.
So I want to kind of, for the sake of our audience, just go through briefly. We just talked about trademarks, which are logos, brand names, product names, but there are other categories of IP. We have copyrights, which are your content, images, music code, AI outputs, your patents, which are inventions, designs, processes. You have trade secrets, formulas, algorithms, data. So I want to ask you, out of these categories, where do you see for a business today is the highest risk of potential infringement?
That's a good question. The highest risk of potential infringement, I would say there's a lot of use of AI generated images out there, but even content, blog content, it could be something that we've seen. I mean, I've seen that actually firsthand where people argue that some of the text is used without authorities, and that also falls under copyright. So I think copyright is one of the biggest areas that we're seeing, but also, in trademarks, if you're seeing people creating digital goods with similar trademark names, you could very much see a trademark claim come up as well. So I think trademarks, copyrights for sure are big ones. Patents, are interesting. I haven't seen as much on the patent side of things yet with, AI disputes. I'm sure that, there will be. And then trade secrets are more, internal formulas, algorithms, data. Trade secrets are generally protected by contract. So you're not going to see as much. But if someone does steal trade secrets, that's still going to be, it could be even come up. I could foresee someone putting in trade secrets into ChatGPT or Claude. And now is that disclosure? Does that void your claim to trade secrets? I bet you that could be a case that we could see in the future.
Yeah, the ground is moving beneath our feet, I think,
Very much
as we
so.
speak. And speaking of
And not
cases,
just because we're in California.
yeah, not just because we're in
Not just because
California.
we're in California.
The legal landscape is changing beneath our feet. And
Yes.
I'll briefly go through because there are some really interesting cases that touch on certain forms of artistic expression. So basically, there was this case, Hermes versus Metabirkins, and Mason Rothschild created and sold NFTs called Metabirkins, which are digital stylized version of Hermes Birkin handbags. Hermes sues Rothschild for trademark infringement, trademark dilution, cyber squatting, and unfair competition. Rothschild argued that his NFTs were protected as artistic expression, claiming they were commentary rather than a use of the trademark in commerce. This kind of reminds me of Nathan for You's "Dumb Starbucks," right?
Right,
That's
right.
the argument. Is this is a form of parody or commentary? But the court completely disagreed, and on all counts, trademark infringement, dilution, and cyber squatting, Mason Rothschild was found to be infringing, and damages of $133,000 were awarded. So I just want to kind of use this as a way as kind of a cautionary tale for our own clients. You know, there probably was an argument for some sort of commentary, but it seems like courts are coming down the other way. Courts are coming down on enforcing a brand's rights and in a way that I think could have gone either way. I mean, we do see often people using parody or let's say the news exception as far as fair use is concerned, but it seems like courts are coming down on the side of the brand alleging infringement. Do you find that to be the case?
Yeah, absolutely. I mean, I think we are seeing that a lot. I mean, and also I think one key distinction here is people have to realize is that Hermes and Birkin are famous brands, are famous marks. And when you have a famous mark, you're afforded additional protection that maybe you wouldn't get as a smaller mark. So that's the issue here is like Coca-Cola, Nikes, they're going to have a much stronger right to protect their trademark than a smaller company like a mom and pop shop. So that's also the problem here is that because they're so well known, they're susceptible to trademark dilution, which is what is happening with which is what the claim was here is that by this NFT using this term, they're diluting the strength of the mark, and that's not okay. There's laws against that. I think that was the issue here. So I think we're going to see a lot more of this. I think there's going to, especially in the the NFT world, the crypto world. I know there's all these like meme coins. Actually, fun. Someone came to us wanting to create a meme coin using a very famous sports brand, and we said, "Well, do you have the rights to it?" They said, "No, but I think we can really appeal to them." It's like, well, if you're using the brand name, you're going to make sure you get the rights. They kind of quickly backed out. But also, it's a big opportunity for these sports brands too to expand in these different areas, which I think we see a lot of them doing right now.
Yeah, I think we are seeing the way that the internet and now AI is expanding the scope and the rapid rate of potential infringement. I mean, this has existed in fashion for a long time. So, having represented fashion brands, I mean, copying is rampant in fashion. And
Yeah,
in terms of the rumors related to fashion, I mean, I know, Punked, you have a lot of experience with it too. There were these rumors that, like, if you change something 35%, you are avoiding infringement, which
yeah,
is not true. But because fashion, even if you look at major brands, Zara effectively is taking runway fashion and copying it in a more affordable version and reselling that to the mass market. They're doing it in a stylized way, but that model of taking what high fashion is doing and then bringing it down to a more affordable level is kind of the fashion industry's oxygen. I mean, the whole
yeah,
business runs on this. You look at someone like Shein or Fashion Nova, that's the whole business model. And people do it at the mid level, people also do it, but it's really rampant and very obvious in the fast fashion segment. That's where you
yeah,
see copying where you're just seeing designs that are not just major brands, but even independent designers will come up with concepts and you'll just see these fast fashion companies walking trade shows. They'll be going to boutiques. They'll be today online. It's very easy to just take a screenshot, send it to your design team and make a similar version of that for your site. And so these companies are getting hit with copyright infringement claims left and right for unauthorized reproduction of artwork. And yet these companies are not backing down. I mean, the business model really hasn't changed. And so you're kind of seeing the opposite of what we saw in the Hermes Meta Birkin case, where
hmm
with Shein and Fashion Nova and other fast fashion retailers, it seems like some of a lot of these claims get settled. They're kind of speeding tickets in the grand scheme of things. But what could be the reason you think fashion has kind of at least the major players have been unaffected by these allegations of infringement and copying.
One of the first firms I started was the Fashion Law Group many years ago. So, we have a background both in fashion, and it's an interesting philosophical debate that I've always been fascinated by is that, does the lack of protection fuel innovation? Because if you look at it, there's a great book actually that was published in 2012 that I read many years ago called The Knockoff Economy. And it's really about that. Like, do we see more innovation because there's less protection, or is there, less innovation because people don't want to enter those markets because they know they can't protect their ideas? So you could argue that you probably see more innovation in fashion. Look at how much there's changing in fashion all the time versus maybe other industries where there's more gatekeeping, right? Protections, there's more guardrails, like in patent law and things like
Right.
that. So maybe you see less innovation because people can't iterate as easily because someone has patent protection and they're afraid of getting sued. So it's an interesting question. I think there's just not a lot of protection for fashion. And when it comes to copyright, the tangible that people wear, there's not a lot of protection for that. There is protection for the images, right? If you take a
Right.
photo of it, you can't copy that image because that's the tangible expression of this idea of this fashion piece. But if the clothing itself is not protected, now I think, in Europe, it's a little bit different. I think there's a little bit more protection in Europe, but in the US, there's not. Same, for example, in jokes. The question is like, okay, how much protection is around copyright for jokes? And I think there's limited copyright there too. So it is interesting that, it also depends on the form of the different IP. But I think fundamentally, we're not going to see, unless there's a big change in law, we're not going to see any protection. I think, like Ralph Lauren, I think was the one that said, like, he's one of the biggest culprits of like stealing fashion designs for the last 30 years, right? He admits it freely. It is an interesting issue, but I think you have to be aware as an artist, as a business person, what is protectable as IP and what is not. And that's why it's important to go back to look at, okay, trademark, copyright, the 4 buckets, and then figure out, okay, what you created falls into any of those buckets, or
Right.
if there's exceptions to the protection, such as fair use, which, we could probably talk for another episode about
Yeah.
that.
So, for example, just for our audience, in fashion, the silhouettes are not copyrightable, but the design elements usually are.
Like the
The
pattern.
pattern, right?
Right.
So, well, and it's funny because actually patterns are usually referred to the silhouette. But
Okay.
yes, the graphics, the design within that garment are usually copyrightable. But like we're saying, oftentimes there are iterations of that. And so it's very hard to tell if the design is actually independently generated or if it is a copy of something else that's just a derivative use. So, like
Right.
you're saying, I mean, it's important to see, at least in the examples we just talked about, the trademark is an easier element to enforce oftentimes than the design itself when
Right.
it comes to
Right.
fashion. Um,
Right. And I think a good point you make is like people need to recognize like what a copyright even protects. And it protects the reproduction of that image or that item as well as all derivative uses. That's the, $100,000 or whatever can be very expensive question to figure out is like, is what you created derivative use? It comes up in music, in television, in movies. Did what you create is a derivative of what that copyrighted work was? Because if it is derivative, then, yes, you've committed copyright infringement. But again, is there enough creativity involved that it changes it, transforms it in some way that it makes it a new work? And that is a massive question and is usually determined on a case by case basis.
Pankaj, thank you so much for this deep dive into IP. I think this is going to be a continuing segment for us because IP is an extremely valuable asset. The ability to protect your IP has become even more important in the age of AI. It's complicated. It requires a tremendous amount of legal architecture to protect those assets because those are the assets that are going to be valuable in your business. They're assets that you can sell, that you can license, and that you need to protect. So you need to have an understanding of what you're actually building, especially today where so many of our businesses are IP based. If you're participating in the App Store, if you are selling online, if you are using ChatGPT, you are maybe perhaps unknowingly in the IP landscape and you're building intellectual property. And so we really encourage you if you're one of our clients or if you're not one of our clients yet and you have a question about IP, be sure to reach out to us. It's an expertise for the firm, and it's a critical asset that you're going to use in your business.
Absolutely, Sahel. Yeah, maybe a few takeaways too that people should consider when they're thinking about IP for their business is, just to audit your IP annually, audit your assets annually. Make sure you understand what IP assets you have. It's not always clear. Maybe there's assets you can license. Maybe there's some ways you can create some more value out of the IP you have. So working with us, working with someone who specializes in IP is important to understand what is that IP? Is it all protected effectively? So we can help with annual IP audits. File early, especially trademarks. Make sure you get your trademarks filed, searched, and filed quickly and early because you don't want to risk someone else taking them. That means also globally. The US, there's an element of use that you have to show. Other countries, it's about first to file. So if you don't beat someone else and someone else in China sees you using that name here, they may very well go and file there, and now you're kind of in a tough spot. So file early, especially trademarks, and think about your global protection. Make sure you're referencing IP ownership in contracts. So you're understanding who owns IP, especially in JVs. That could be very complicated. And clear also agreements with your developers and your designers. Make sure there's an IP transfer agreement with all those developers and designers because you do not want any loose ends where people could be creating IP for you and then not have it properly transferred. And now that could also hurt you in the sale of your business later on. And lastly, don't ignore cease and desist if you get it. If you get a cease and desist, talk to us. We offer half an hour consultations for not a ton of money in the grand scheme of things that can help you kind of navigate these cease and desist letters because some firms are much more aggressive than others and you should know which ones. And because we've been doing this for many years, we kind of know which ones to look out for and how to deal with each one specifically. So those are kind of some takeaways I think that people should keep in mind.
This has been really informative. Thank you all for joining us again on this segment of Letters of Intent. We will be back next week, and we hope that you will join us then. Until then, we thank you all for being part of this community. This is a community for risk takers and deal makers, and there's never been a more exciting time to be in the game.
Absolutely. Couldn't agree more. Sahel, thank you for joining us from across the world. Wonderful to always chat and have these conversations for Letters of Intent. If you guys do find this helpful, please like, share, comment. We want to hear back from you. We want to make sure this is as useful as possible for you all. So until next time, dare to deal.